Welcome to the Spiggle Law Firm podcast, where we talk about cutting edge issues in the news that affect people who've been fired or afraid that they might be. Today, I'm thrilled to be joined by an attorney in my office, Zachary Aman, who has had some great topics before, and I think we're going to stick with his theme of talking about sports. But before we get into that, just a little bit of legalese. This podcast does not create a legal relationship with the firm, nor is this intended to be legal advice. This is educational information for you. If you want advice on your specific case, then you got it. You should go hire a lawyer. So with that fine print out of the way, Zach, let's dive into it. What are we talking about today?
Sure. So as you teed up for me, I'm bringing another sports story into the pod room today. So last week was the WNBA draft, which is crazy because it happens 1 week after the national championship game for the women. So a condensed timeline. I believe their first actual in-season game is less than a month from now. So very condensed. But their draft was last week, and after the draft, there was a lot of discourse online about player salaries, how much the women are getting paid compared to the NBA, the men in the NBA, collective bargaining agreements. And, we talked a little bit last time about unions and how they're helpful. So I'm not going to dive into the union part today, but I just thought it was interesting talking about negotiations for, the salaries, revenue splits, things like that with the women's game. But as it relates to people who might be interested in or need our help, our legal services, what goes into negotiating, whether it be a contract or more specifically for us, whether it's a severance agreement, separation agreement, settlement agreement, general release. These are all names for the negotiation at the end when somebody's been terminated or is about to be, and they think they have some leverage. So I thought that was really interesting as far as how it compares. So, these agreements are put in place between the employer and the employee, and in exchange for the employer's waiver of their right to sue based on certain violations of law, they are entitled to usually some monetary benefit. There's generally something that's called a neutral reference, where if some future employer calls, they can just confirm that you worked there from X date to Y date in Z position. There is mutual non-disparagement, which means both sides can't talk bad about each other later. A confidentiality clause is always there. We see those where neither side can talk about the deal, what went into the deal, the terms of the deal itself. So just really interesting how you can pick and choose the things that you really want to hammer on and you want to negotiate, the things that are your 100%, I must have this in the agreement, versus the ones that are, well, I'm willing to bend a little bit in order to get those things that I really want, whether that's a monetary amount, some specific clause, things like that.
No, absolutely. And with professional sports, it's always fascinating to me. I mean, as you mentioned, there was a lot mentioned about Caitlin Clark and how much, she's getting paid compared to the men, which is, I think she's 80,000 or around thereabouts.
Yeah,
And
76, I think, first year,
yeah,
going up to year 4 is a team option where it would be 97.
yeah.
Um,
I think the
somewhere
lowest
in
paid
ranges.
man is like 7 million. I forget. It was some order of magnitude, many
Right.
orders of magnitude greater than $76,000.
Right. And it's just really interesting again to look at those, what goes into those contract negotiations, or those, the CBA, the collective bargaining agreement.
Yeah.
So the players have a players union that negotiates on their behalf, but, really sticking into what the players want, what they can get out of each particular deal. Their last CBA was negotiated, I believe, in 2016 or 2017. Um, and there's another one. The next opportunity for them to opt out and go back to the negotiating table is within the next year or so, whenever their TV deal when it coincides with like TV rights expiring. So it'll be really interesting to watch those negotiations. But again, taking it back to our clients, like those negotiations, there is no season for that. It's whenever something bad happens at work, or whenever they've been terminated or whenever, or they quit because they've been discriminated against, they've been constructively discharged for or something like that. So it can happen at any time, and so it's important to know the types of what factors go into negotiating those types of agreements in order to make everyone, I won't say happy because not everybody's happy walking away from a settlement, but where they think it's worth it to get what they can at the negotiating table now versus going through, whether it's the administrative agencies that we have to go through in some of our cases before we can get to litigation, or even moving into that litigation phase before going all the way through trial and having to sit for depositions and having to attend trial and make sure your witnesses are there and all that. So it's a calculation, figuring out what you want, figuring out what your walking away point is. So at what point it doesn't make sense to keep negotiating at this point. Not saying you can never do it, but I'm sure you've had this where, you've been in a negotiation for a couple of hours and it just doesn't seem like there's a lot of movement coming. While both sides are working in good faith, they just have very different views of the facts, and maybe it's going to take a little more fleshing out of a little more key facts before it really moves the needle for anybody. So you have your walking away point as to how much time you're spending on in the negotiation. It could be a dollar amount, so you say, I don't want to settle for less than X amount of dollars. If if they're just not coming up to meet that, then it may not be a productive use of time to continue for several more hours trying to negotiate that.
No, absolutely. And going back to the sports analogy, I mean, obviously, for most of our clients are not in a union, so there's not a collective bargaining agreement. Unions are great for that reason because, right, you go in as a group and you usually have professionals on both sides, as you do in a private mediation. But you have there, to your point about looking at the entire package. A union for players might be looking at certainly not only salary, but health care, time off, maternity leave, all those sorts of things that can be equally as important. And in some ways, getting back to a mediation in an individual case, what I would call sort of like non-monetary factors, they have value, but it's not as if at the end of the day that company's writing a check for.
Right.
For them, whether it's waiver of a non-compete or something like you said, like a non-disparagement clause, other things that may be, or healthcare benefits that may be very important to you, maybe more important than the actual settlement number, and having a good sense of what that is, like you say, before you walk in there. Not that you can't make some, using our sports analogy, some game time decisions, but so you're right. So you have some broad, outlines of, this is what, what I'm hoping to get out of this. This is what my absolute lowest number that I'm going to walk away from. And to your point, yeah, absolutely. It's not uncommon to go into a mediation and find out that both sides are so far apart and they're not willing to move. There's not going to be productive. It still can be useful because you're learning about the other side, right? You're learning what their positions are. It's all confidential. You're not going to be able to use it at trial, but you can certainly, get a sneak preview of what their defenses are going to be, what things are important to them. And sometimes even if a mediation initially fails, as it can lay the groundwork for a later subsequent successful settlement because people have started working through some of these issues. But and again, getting back to like Caitlin Clark, I'm sure for those players, part of their negotiation are the private sector deals, right? Like I think I heard she has like a $20 million contract with
Nike.
Yeah. So she's gonna be doing okay. I mean, she should of course be doing as well as the men, but I'm sure that's a piece of it too. And it was for her. It's not like she's going to be, like a poor college student eating ramen noodles and, McDonald's. She's going to be doing okay. But those might be been factors that went into the CBA that the whole team was looking at. Is yes, the salary's not as high as we want. In 4 years, when we look at TV rights, we're going to want a bigger piece. But for now, we know we can get these. And I don't know. I was not privy to those. I've never done those kind of collective bargaining agreements. But I got to think that's part of their analysis is, what's the total package look like? And like you said, for our clients, for people we work with, we want to make sure that you're aware of what the total package might look like, because I've certainly had situations where everybody in mediation are focused on the number. What's the check that's going to be written at the end? And of course, that's very important, right? We all
Mhm.
want more. We like a bigger check rather than a smaller one. Um, Only to find that afterwards that there was some part of the deal that was going to be just as important that becomes a sticking point. So like, we'll get the agreement afterwards, which is often written by, in first instance, by defense counsel. There'll be some language in there that's completely objectionable, like you said, like maybe a lopsided non-disparagement agreement, or they sneak a non-compete in, or a no rehire provision, so you can't apply to this company again, which most people don't want to do. But if it's a multinational, like, you might not want to work in
What is
Denver, but you
defined
might,
as the company? Sure.
yeah, you might be willing to work in, Chicago or wherever it may be. So to have a good sense of what those are, and a good mediator, and everybody gets swept up in this and people forget things, but usually a good mediator will bring that up. But if he or she doesn't, and not all mediators are created equally, it's important for our clients, when we're working with our help, or if you're an employee working with your attorney, you're like, okay, what agreement, broad outlines, because usually you're not going to get the agreement written in the mediation, but like, what broad outlines, everybody knows that what key sticking points could be, particularly if you've got an experienced litigator on the other side. What kind of non-disparagement are we willing to sign? Are we willing to have a non-compete? Is a no hire provision on the table? And again, you're not going to have the language hired out, but you could, written out, but you could have, up or down on these topics, and then it's just a matter of memorializing it.
Yeah.
So to your point, it's understanding what the total package is, and time value of money, and just time generally, as you mentioned. Just a plug for our book that just came out called "Fired or Afraid That You Might Be," which you can get your copy on Amazon. We talk about that, where if you're the total value of your case, and I'm just picking a number out of a hat here, is $100,000, and that's if you go to trial and knock the top out of it and win every possible damage you could win, and you're at mediation and they offer you 50. Well, first of all, bird in the hand, and you're probably at mediation very early in the process. And as you
Yeah.
mentioned, like, is it worth it to you to let go of that? And it may be, there are no right or wrong answers here, to let go of that and plow forward into litigation, which could take months, sometimes years, for an uncertain payout of $100,000, because you could, of course, lose and get zero. So again, sometimes it's worth pushing forward. You got to have a sense of what your own priorities are as a litigant and as an employee, and have a clear-eyed understanding of what you're leaving on the table if you walk away from it.
Yeah, I agree. I think, you brought up a good point earlier with the CBA and the sports. Is like they may have taken a deal now to then fight another day about some other piece. And I think that we see that all the time is, we not necessarily taking a deal now and then getting another one later, but, you know, knowing that it's okay to walk away and you don't have to come up with a deal. I think a lot of people feel like once they get in, it's this or nothing. And so they have to, go back and forth and really decide, is my walking away point really my walking away point? And it's like, once you get in there, you don't want the rationale from choosing your walking away point to go out the window just because now you feel like you may lose something, bird in the hand. And it's okay. Like it's okay to leave one instance of mediation or settlement negotiations, do have a little more work done, progress a little further in the case where some of those facts are fleshed out a little bit, and then come back to the table. So I think, again, just knowing what's important. Is it important for you to get this wrapped up quickly and move on with your life? Is it important that you receive a certain type of compensation, whether that's monetary or not? Whether it is a sense of moral justice that you think somebody did wrong and so they should have to pay for it. It's whatever. What you need to figure out what those things are before you get into the mediation, in order to know how to direct the mediation. And I think that that's something that we do really well, is sitting down with the clients, explaining, look, your best day in court, this is probably the number that you would walk away with. You got to discount it a little bit because we're not there yet, and because of the fact, you may get there and you may lose. That's if you win. This on your best day is this if you win. So I think that that's very important to remember. Is it's not a sure bet there, even if you have the best facts, and even if it seems pretty cut and dry. you never know with the jury.
Yeah.
Well, you never know. So being able to control the negotiations and say, this is what we're willing to do, this is what we're not willing to let go, I think has its benefits as well. And then, as you said, just the time value of money, and then just the time value of time, the
Yeah.
time value of your effort in preparing, as you go further and further through the process. Those are all considerations to make, and that's something that an attorney will help figure that out. Once you get in there, if you have a private mediator, they're supposed to help. Both sides really keep their eye on the prize there as well.
Yeah, I think it's a good point. You don't, yes, you want to consider a good bird in the hand, but you shouldn't feel strong armed in just accepting a settlement. Usually even a settlement that doesn't work out on the day of, a mediation that doesn't work out on the day of mediation results in a settlement doesn't mean that there won't be one subsequently. I had a case, a number of them like this, and if you're with a good private mediator, and that's another thing probably for another podcast, but just to talk briefly, you get a private mediator. This is somebody, if you go through the court system, you can have a judge who mediates your case. If you go through the EEOC or an administrative body, they have mediators that work there, and the quality varies widely. You can get some who are very good, and you can get some of them who you can tell their most pressing thought is like what they're getting for lunch, and so
Mm-hmm.
they're really not putting, because they don't, particularly for administrative bodies, they don't. I don't know. There's no incentive for them to settle, but they're getting paid either way. Judges, it's a little different because they like to clear their calendar, but at the same time, some judges are, what makes a great judge doesn't always make a great mediator. So they can, sometimes not be the best. But a private mediator, and that's somebody that both sides, sometimes one side, but usually both sides pay for. It's usually a retired judge or somebody who's really senior in the field. I mean, they will go the extra mile. I had a case once where we went all day, didn't reach mediation, and that mediator, private mediator, he got on the phone with both sides. It took another 2 days, but he got the case settled. And sometimes, it just takes a good night's sleep. So I think as a client or somebody who's going through this, while yes, you don't want to give, let go of a bird in the hand, particularly if it's a good one. But at the same time, you don't want to, make a bad deal just because it's 9 o'clock at night and you're exhausted because, as you say, you think this is the train's leaving and this is your only chance, because that's rarely true. Even if it doesn't subsequently settle in that mediation, depending on where you are in the case, it really doesn't matter. But there will be multiple opportunities to revisit settlement. As you say, there may be more information that comes out later that changes your side or one side's view of this. And having laid the groundwork in an earlier mediation, you can get it settled. I will say, just a cautionary tale, though, about bird in the hand. I had a mediation this years ago. The defendant offered my client, it was a 6-figure settlement. It was a great settlement. I advised that she take it, and she had a family member there with her who was clearly had a different view of the case and the value of the case, and so she wanted to talk to her family member alone, and which is fine. So I let them talk, and came back in, and she decided that it was clear to me that like this family member of hers had stars in his eyes about what this case was worth. And I understand, like we all get, you know, exuberant about it, and you want justice, and certainly, the way she is damaged, I can understand wanting to push for more. But what ended up happening, they turned down that deal, and the company later went bankrupt. So she ended up getting, I don't even know if she got, because there was no judgment, because the case went bankrupt after the company went bankrupt before it went to trial. But the point of it is, she didn't get her $100,000 or anything close to it. So, it's a balancing act. You got to be talking to your attorney and make sure you're clear eyed on the decisions that you're making. And there's no right or wrong answer. Like, sometimes the appropriate thing is to walk away from a bad deal. And sometimes, like you said, Zach, it's usually both sides. If both sides leave slightly dissatisfied, then it was probably a good outcome.
Probably a good day.
Yeah, right, right. So, anything else you want to add to that topic before we call it a day?
No, I think that's it. I think, it's very important to make sure you have your bottom line, your walking away point, whether that's a number, whether that's a certain clause. It's important to know what those are. It's important to know what you're willing to be flexible on in order to negotiate and get the things that you really want. It's also important to make sure that you think of those things before you go into the mediation, so you have a clear eye on what it is that you want. And then, not to say that everybody's emotional in a negotiation, but it's an emotionally charged conversation usually, especially if there are multiple parties involved beyond just the attorneys. If you've got, the family member, or if you've got the alleged bad actor on the other side in the meeting, things can get very emotionally charged. And so it's important to know before you go in what you're looking to get out of it. And that can help really cut down on the time it takes to get a deal done. It can cut through some of I'll say, the extra stuff, and where you can really focus on what it is you're there to do. And it's to decide if this is a good deal or if it's not, and what's the best way to move forward for you in your particular situation. And like
Yeah.
you said, there's no right or wrong answer, but I think the best way to do that is to have clear thoughts before you head in.
Yeah, absolutely. All right, Zach, I appreciate it. I'm going to let you jump off so I can say goodbye to our audience, but great topic. Always enjoy having you on.
All right. Have a good one.
All right. Thanks, everybody, for joining this podcast. If you'd like some more information like we shared here today, you can go to our website, thecareerrocket.io, where if you give us your email, you will weekly get a information-packed email to you with the latest and greatest in employment law and resources that we're generating at the Spiggle Law Firm, in addition to other information that helps you keep your career on an upward trajectory. And of course, you can go to our firm website, spigglelaw.com, where we have a lot of information about employment law rights that you may find helpful. In the meantime, best of luck out there.